Welcome to day 2 of the federal court appeal of JCU versus Peter Ridd, appealing Dr. Peter Ridd's win in the Federal Circuit Court. My name is Evan Mulholland, Director of Communications at the Institute of Public Affairs. Today I'm joined by Gideon Rozner, Director of Policy at the IPA. Now, Gideon, today we saw Stuart Wood QC on behalf of Peter Ridd really delve into the facts of the case, whether it be the Alan Jones interview on Sky News or the confidentiality agreements and what JCU put Peter through. Can you tell us a bit about what happened?
Yeah, well, as you said, it was a different day today, a very different day. Yesterday we heard mostly from Brett Walker on behalf of James Cook University, and today we heard mostly from Stuart Wood on behalf of Peter Ridd. Now, yesterday, as you said, a lot of the discussion turned around what they called the construction of the enterprise bargaining agreement and how the code of conduct fit into that. And that was really involving a lot of questions of abstract law and legal principles. Today focused more on the facts. It focused more on how the academic freedom clause was trampled over by JCU under the pretext of the code of conduct and its requirements like collegiality and respecting reputations and so on. So I think today we saw the extent of the injustice that occurred in real terms and what exactly JCU put Peter through, whether it be the confidentiality directions, which may have been bogus anyway and were certainly found to be bogus on the lower court level in the a trial, including the direction that Peter couldn't even speak to his own wife, but also things like the Alan Jones interview, you know, the infamous interview on Credlin and Jones about that came out just after our book Climate Change: The Facts was published, and really, as Stuart Wood read through the transcript of this interview and how benign and how harmless it was, it really showed how much JCU, at the very least, overreacted. You know, things like saying that certain science couldn't be trusted because it wasn't quality control checked enough, or the fact that scientists were too emotional about the reef and weren't as dispassionate about their science as they could have been. You know, maybe strong comments, but they did not really, in any sense of fairness, amount to academic misconduct, which is exactly what the university eventually found Peter had done.
Yeah, and I found it very interesting and very pointed that, you know, Stuart Wood was saying if we can't call for quality assurance, and what he means by that is checking facts and then checking and checking again. It's not just an end to academic freedom; that's an end to the scientific method altogether.
That's a good
line.
He
said, you know, in losing and in ending that academic freedom, JCU can no longer call themselves a university, but can call themselves a public relations outfit. So I thought that was very pointed.
Yeah, I loved that line, and that was just vintage Stu Wood. I mean, it took me back to watching him in the Federal Circuit Court make his powerful closing address in favour of Peter, which we partly featured on The Heretic with a voiceover and recreated because it was that good and that important. But we certainly saw that shine through today. And conversely, Brett Walker did have a right of reply at the end, and I'm not sure that he had as good a day as Stuart Wood did because he, as we all know, the academic freedom clause in the enterprise bargaining agreement is not completely unlimited. There are some limits to it. You cannot say anything in an academic sense which intimidates a colleague or bullies a colleague or threatens a colleague, which is absolutely fair enough. What Brett Walker tried to do is use the code of conduct as a pretext for reading in additional limits like you can't use intemperate language, which, intemperate language might not be nice, but is it academic misconduct? I really think that would cause a very, very bad chilling effect in academia if academics who want to speak out, and indeed even call out scientific fraud, as you were saying, are worried, I can't say that, it might be found to be intemperate language. It might get me strung up by a bunch, academic university administrators and so on. So I don't think Brett Walker quite succeeded in making that argument, but as we'll see, it depends on what the judges come back and say.
Their argument really seemed to be that the Clause 14 of the EBA, which is the Academic Freedom Clause, and the Code of Conduct should be read together. It was trying to blur those lines. And I also note that Brett Walker said that Peter Ridd wasn't actually stopped from putting out his research or he had his research interfered with. But as we know from the Heretic podcast, they were vetoing slideshows of Peter's and things like that. So I thought that was very interesting.
Yeah, well, that's right. That was a fact that came out in the Heretic, that and this is what actually, ironically, clinched Peter's decision to fight. He was going to do presentations to the IPA and other organisations,
Institute as
and the
well,
Sydney
yeah.
Institute as well, very fine organisation. And by that point, JCU were demanding to see the lecture slides he planned on using, and took some out. And at one point, Peter said, it said to himself, or said to say to the crowd, sorry, my university is not permitting me to answer that. And that was the point at which Peter said, look, I can't live under this any longer. I'll either have to shut up completely or I'll have to fight. And that is unfortunately why we are where we are now.
Well, I think this is the most important academic freedom case in our lifetimes. Yep. If a judgment is set that collegiality is to be written into academic freedom, then academic freedom no longer exists as we know it. Yeah. It is very important. And to everyone watching, keep up to date with this case at ipa.org.au/Peter Ridd. The judgment is expected to be handed down within a few months, and we'll keep you updated as we go along. So thanks for joining us.